Good afternoon, all. This trial is in the matter of CFI 053-2022 and is being held by way of video conference before His Excellency Justice Sir Jeremy Cooke, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Al-Suwaidi and Company. Lead counsel is Mr. Mohammed Al-Suwaidi. The defendant is represented by Concelis Law. Lead counsel is Mr. Raza Mathani. Thank you, Your Honor.
Thank you very much. Yes, Mr. Al-Suwaidi, I've obviously read the skeletons and had a look through the...
skeleton?
I've read both skeletons and I've looked at the agreements in question, but please carry on from there. Thank you very much.
Oh, thank you very much. Good afternoon, Your Honor. Welcome back to Dubai. And before really proceeding with the case, I would like to give a little bit of a history about Dubai that I think a little bit is relevant to this case. Very simple thing. You know, in 2008, we had a crash which is a real estate crash. I mean, the whole world, and we also suffered a lot.
Yeah.
And banks were really burned, you know, with the loans that they gave for all the real estate developers, real estate buyers. And we had the issue of people just flipping, you know, the whatever title they buy, even something on has not been built yet, but it's just on the paper, and they will just sell this to to a third, fourth, and fifth even buyer, and this is all just on the paper. In fact, things were so interesting before that people will always line up. Not only line up, they would even buy the chance to line up, you know, to be first to buy this property. So everyone was burned and really suffered, and loans were not given by the banks. So consequently, MAHDI, as I remember, was a very good developers coming, you know, as other developers here like Damak and others. But they are not as big as Damak, but they are big. You know, you could see AMJAD's name everywhere. And Mr. MAHDI AMJAD was one of the pioneers on this. And UAE or Dubai community at the time is also smaller. It's not like what's now, smaller. People knew each other. People, especially developers, contractors, they're building with each other. They know each other, especially the expatriate, you know, people, or both parties are. Usually they would know each other. They, you know, meet each other and do business with each other. And because of these kind of relations that they had, and you know, I was, sorry, I was just looking now at the website of MAHDI. You know, I was just looking how, because MAHDI, one of the companies that they suffered during that crisis because of the cash, because the buyer was not really paying, you know, their dues. So developers were not able to develop the property. When I look at the website of MAHDI, I mean, even I could say share the screen, which I really liked, you know. It said they have 3 destinations, like different countries. They have 18 masterpieces. They have 18 US 10 billion portfolio of real estate, 10 billion US dollar, not millions, billions. MAHDI at the time was a millionaire. Now he is a billionaire. So we're not talking about someone who is really financially incapable of paying his dues here. He is a very, very wealthy man. At the time when he asked for a loan, you know, although the name is not MAHDI and that agreement, the first loan agreement 2012, his name was not there, but it is because of him. He is the one who arranged everything, and those are part of his developments. At the time, they will put some of the development in the name of some of the local people, you know. So he would be able to get some specific lands and things like this, because at the time, not all lands was owned by allowed to be owned by non-UAE residents, non-UAE citizens. So he was giving the loan. Of course, the defendant is trying to now talk how bad is my client is, how he is charging too much interest, how much he is a shady character. Of course, they did not say all of these things when they asked for the loan. They are so good in really asking for the loan and getting the loan. And they got the loan. This loan is not to help someone, you know, to pay for his medical expenses or his mother's, you know, home nursing or whatever. You know, it is about using this money to make investment and develop properties. Maybe because of that loan, Omniat is still in existence now. Because of that loan has a 10 billion US dollar of investment, okay, and portfolio because of that loan. And if you look at our case, it's purely simple, easy to understand, easy to comprehend, and easy to issue an award or a judgment on. The reason is we had an agreement, 2012 agreement, and then it was replaced because they did not fully pay the money. They had to be replaced by a loan settlement agreement of 2018. That is the core of our claim. That is the main agreement that we talk about. Because that agreement, it introduced Vision, the claimant, as a beneficiary of any payment to be made on that loan. This is number one. Number two is that Mr. MAHDI AMJAD is a guarantor of that. He's the one who signed that agreement, who he signed on this behalf of the company, but he also signed on him in his behalf, being the guarantor of this payment. He had not been the guarantor, this loan would not been agreed to, and he would not even been giving this loan in the first place. Why? Because they knew each other, they respect each other, and I don't know what happened between them in the end, but they don't talk to each other. I really wished they talked. I mean, if Mr. Mahdi has a 10 billion portfolio, now he started not to talk to the people who supported him. I don't know. But if he had made a call even to my client, maybe they could have sorted this out. But he didn't. So if you go to this agreement, and I don't know if Your Honor, you can allow me to share the screen, because that will be easier, so we can see it in the front of our eyes. Would you allow me for that?
If you want to, I've got a hard copy of it. I printed off the agreement and the addendum as well. But whatever you find easiest.
That would be much easier, you know, just to see the screen, because then we all see that. But you know, I want to just. Okay, thank you. Because we have to make use of the technology, you know. How to do. I'm just trying to, because I'm also not really that great on this, but I'll see what I can do. Okay. Okay. 1 minute. I don't know why this is. Okay. This is coming up. Okay. This is the agreement. This is the loan settlement agreement. It's written in Arabic, because both knows Arabic very well, you know, and it is between Town Square and Khaldun al-Tabari. And then later on, it shows the amount is outstanding, it shows the amount that has been paid, and also state the amount is due, and state the installment. I'm just trying to reduce this, so I'm sorry, I'm scrolling so fast here. My mouse is really fast here. Sorry about that, Yani. So it shows, it shows, okay. I always have a problem, Your Honor, with all these translators. Keep putting their logos on the document they translate. So you get confused sometimes with those things. So this is, I said, this is the contract. This is the town square investment. And this is Khaldun Tabari. And it shows the amount, it shows how much has been settled, how much is outstanding. Very simple. And it says, clearly that these units, and they're supposed to buy some units, but then later on they made an amendment to the contract to cancel that payment. My client is so cooperative to arrange that he could receive, his money, not if they don't have the cash to have it in kind, but they did not give him. They made things more difficult for him. So here I want to show this important. See, in the event of any of the above mentioned checks bounce, Mr. MAHDI AMJAD shall be the guarantor, personally responsible, undertake to pay the amount of bounce checks, within 90 days. Okay? And this agreement, okay, has two things. Has, as I said, the obligation, the undertaking taken by Mr. MAHDI, and the right that was given to my client Vision Investment to receive the proceed of these payments. This is covers in the UAE law by Article 252 of the Civil Procedural Law. Your Honor, I need you to just, I want to draw your attention about how the structure of the UAE law. We have the civil code, or they called it the civil transaction code. In fact, they call it the father of all the laws. And this is the law that governs most of the relations of any transaction, anything that is in the UAE that will govern in general. And then they will be becoming a specific laws. Some commercial transaction law, company laws, and all these laws that are related to the, doing business in the UAE. You name it, trademark laws. And in case they couldn't find anything there, or labor law, they will go back to the civil law. Okay? So the civil law is the main law. And when there is a specific law, like the commercial transaction law, and then you will go to the specific part of that law to cover whatever that is missing. So as per the Article 252 from Civil Transaction Law of 1985, it says, the contract does not impose any obligation on a third parties, but may establish right in their favor. And this is where we are. The contract gave us, as Vision Investment, gave us the right, to receive the proceed. So we are within the law, to seek this right. Of course, the defendant is saying, no, they have no right, which is totally wrong. I'm sorry. But this is the law. And this law is not unique. It's applied, a lot of civil law countries apply it, even common law. Even the DIFC laws state that. If you go to contract law, DIFC law number 6 of 2004, it said, part 10, Article 104, it says, rights of third parties. Rights of third party to enforce contract terms. I would draw attention here to be subject to Article 10, 104.2, the term purports to confer a benefit on him. So it gives you, if you have, right to third party to enforce a contractual terms, if it gives him a benefit. The same as 252. We in Arabic, Your Honor, we pride ourselves if you try to be as concise as possible. The less you write, and the more meaning in whatever you write, the more the better you are. Let's put it this way, okay? The better writer you are. So if you can see, this whole thing is mentioned in one liner here. And that's sometimes always a problem for the translation, that you have to really write more sometimes in English. This is when we talk about our right to do this. Okay, so there is a right that was given to us, and we are using it. Now it comes about the obligations of Mr. Mahdi. Obligation of Mr. Mahdi is there in the civil law, but it's most importantly because this is a commercial transaction, it's a commercial loan to do a business with it, then the commercial transaction law would apply. Okay, and that's, we will, of course, we have listed all the articles that covers this in the commercial transaction law, that shows that Mr. No, 1 minute, just to see. I'm sorry, I'm just here.
I'll ask you a question in a moment, Mr. Al-Suwaidi.
Yeah, go ahead.
Because it's a commercial transaction law, commercial transaction in your submission, do you say that has a 5-year limitation period or a 10-year limitation period, given the dates of this transaction?
Okay. I want to talk about this because we made a little bit of a mistake by referring to some of the new laws. We have I want to also a little bit of history here. In the last 3 years, 4 years, there's so many laws that get amended, 150, 160. Imagine, I lost track of it, frankly, as a lawyer. And I have to re-study. And the problem is people who are in charge of this, unfortunately, who are following this. I mean, the idea of the country is to bring the legislation up to date as quickly as possible, so it meets the criteria of the World Bank of, the best countries in doing business. And the people who did this did it so quickly. In fact, they changed sometimes they change the articles. The same article, they just gave it different number, which get us confused, because if you go to the precedents of all courts before, it gives you a number, and now the new laws gives you a number. The article almost identical. When this transaction took place, 2018, the applicable law at the time is law number 18 of 1993. Of 1993, which then later on replaced by law number 50 of 2022. It actually came even after we filed the case, So this transactions, actually what's applicable to it is actually the 10 years limitation, because at the time, when the transaction took place, that law was applied. In fact, even after we filing the case, it became, at the time, the law was not applicable, the new law, I think. Well, I mean, if you allow me, I have to check this, if you don't, please.
It isn't going to matter, is it, Mr. Al-Suwaidi? Because whether it's 10 years or 5 years, you say you're in time.
Yeah, I am on time. So it was 10 years, and now if we apply the 5 years, we're still on time. But the law applicable, because it's deprived the client of rights, and the 10 years will be applicable.
Understood. Thank you.
Okay.
I'm sorry, I interrupted you.
No, it's okay. It's okay. I mean, the other, I'm just putting all the laws. I'm just trying to be. We put here all the things that we rely on. That shows that sorry, would you allow me, please, if you don't know?
Is it Article 70 you want to look at?
I thought it was missed from this. I apologize. Article 70, a suretyship shall be commercial if the surety has guaranteed a debt which is deemed with regard to the debtor to be commercial unless otherwise provided for by law or agreement, or if the surety is a merchant and has an interest in guaranteeing the debt. Of course, Mr. Mahdi is a businessman and he has interest in this securing this loan because he used this money to build up his empire. Okay, now talking about 72, when my colleague said that there is no this is a usurious loan, and my client is trying to circumvent the criminal law and put it next to the bank, and all these kind of things that he's trying to say. The law allows this kind of interest to be charged. In fact, the new article, which is 72, it says a maximum of 9% in case of disagreement. The old law, which is applicable, it says 12%, not 9%, it says 12%. So the charging interest in a loan like this is very normal because this is a commercial transaction. It is, as I said, we are not helping him to buy some medicine for his mother or himself. We are helping him to build up his empire. Of course, my colleague, in his defense, I mean, he had so many issues he tried to defend me, because why he wants to distract us from this simple arrangement and simple application of the law to take us to criminal law, shady character, talking about limitation under check transactions, all of that. This is not a check transaction. It's not a check transaction. This is a repayment system where the parties agreed. Okay, can I say that something here? I'm going to take you back here a little bit. Sorry, Your Honor. In the system in the UAE here, the people use checks extensively to kind of secure their payments. The bank use it, whatever, if you are going to go buy something in credit, they will ask you to give them a check. At the time, checks, any bounce checks will be punishable by jail sentence. It was later, of course, changed. But if a check bounced, you take the check to the police, and the police will be the collector for you to this. And in fact, the police were complaining that why we are acting, as a collectors for commercial businesses. And then the law later on get changed to does not make it a criminal on certain ground, but some grounds still could be still considered as commercial. And so here, this case and many other cases, checks here is not the source of the obligation. The source of the obligation is that settlement, the loan settlement agreement. Here, the check is just a mode of how receiving the payment. Take the check, you deposit, you receive the money, And at the time, by the way, not a lot of banking transaction. Now, in my firm, I rarely sign checks. But before, I signed too many checks. Any payment checks. I had even asked my colleague, my partner, to be a signatory because we have to sign for any payment by checks. Now, payment could be done by online transaction, I could tell, you can ask my wife because she always asks me to transfer. Anyhow, so and even if we could consider this, even for remotely, if you go to Article 670, which is actually in the old law, it will be 638. By the way, I put a list of all the numbers. I want to send that to you. It's just, they're all identical, just different numbering, It says, the above mentioned time limitation, which my colleague is trying to rely on, shall neither apply to a drawer who has not provided a consideration for payments or has provided it, then withdrawing it in whole or in part, nor to the lawsuit against all obligors who have earned an illicit gain. The idea is that you should not take advantage of the system. You know, it should, if you put your money and then take the money out so that check will be bounced, you know, or you have a normal check, but you make sure that this check is not getting cashed. So in order not to allow people to take advantage of the system and deprive innocent people like my client to be from their due amounts. And you know, this is, I could conclude actually my argument is very simple. As I said, it's very simple. We need our client's money. He is entitled as per the law to receive his funds. And this is not a check case. It is trying to enforce an obligation as per the settlement agreement. Mr. Mahdi, he signed the agreement. He knows his name is there. Because of him, he was giving the loan. Because of him, this loan settlement agreement was entered into to reschedule the payment. He knows what he's doing. He is aware of it, and he's an Arabic speaking who signed this. He's an Iraqi. By the way, Your Honor, I want to show you something while we are here on this. See, this is the website of Vision Omniat, you know, Omniat, and yes. And this shows, you know, the 10 billion portfolio, and this is Mr. AMJAD, you know, nice gentleman. He just doesn't want to pay my client. That's all.
Your Excellency, I hesitate to interrupt Mr. Suwaidi.
I'm done. I'm done. I'm going to even take out the sharing of this. Thank you very much.
Just one question for you, Mr. Al-Suwaidi.
Please, Mr. Honor.
Looking at the loan settlement agreement, I'm looking obviously at the English version. I've got the Arabic as well in front of me, and I can see that there's a signature on each page of the agreement, but the signature at the end on the part of Mr. MAHDI AMJAD is a signature that is made on behalf of the company. So he's not on the face of it signing personally, is he? So the question I have for you as a matter of UAE law is, how is it that if he signs as an agent for the company, he can be liable in respect of what is said to be a personal obligation that appears in the guarantee provision? You understand?
I understand this very much. You see, if the one who is signing on behalf of the company here would be the manager of the company, you know, then Mr. Mahdi AMJAD will not be liable, because someone else is obliging Mr. Mahdi to be the guarantor. He cannot. Here, Mr. Mahdi sign his name, and he saw his name. Not only saw his name, also if you go up view of all, I'm just trying to, all of them, he signed all the pages. So even the page where his name is mentioned as a guarantor, he signed all of that. Of course, here it's enough for us that he signed and see his name, you know. And if you notice here, if you go to the first page, okay, first page, it's mentioning the name of the company, right?
Yes.
And it does not say even represented by Mr. Mahdi.
I understand.
Mahdi AMJAD. It doesn't say you're in the other company, in the other loan agreement. I think it was signed by his manager. I think I don't know. Let me see if that. I just want to look at the agreement.
Can we just look at? Can you look at the actual signature page? Obviously, I've got the English translation, but I can look at the Arabic. I don't read Arabic at all, I'm afraid. in the translation, it simply says First Party Town Square Investment LLC, and then there's a signature below it. Is that right? And the signature is,
okay. Yeah, and each page, he signed.
No, I understand that. No, I've got that. Yeah, I've got that. There's a signature on each page, which is simply his personal signature. I understand that. If we look at the second party, which is Mr. Al-Tabari,
yes,
he then simply signs, does he?
So
we've got Town Square Investment, and underneath that we've got the signature of Mr. MAHDI AMJAD, and on the other, for the other party, is Mr. Al-Tabari, who signs personally himself.
Yes.
Right. And when we come to the addendum.
Where's the addendum? Okay.
It's exactly the same.
Same. The addendum, please. It's not showing here the addendum.
In the bundle of documents, it's page 25, I think.
This is the amendment. Yeah. Okay, but okay, the addendum, Your Honor, has only tackled two issues. Which is
I understand that, Mr. Al-Suwaidi. I'm just interested in the signature page for the moment.
Okay.
Do you have that?
Yes, I have that. Yes.
So I'm looking at the Arabic, and what exactly appears on the left-hand side above Mr. Amjad's signature and below his signature?
Sorry, an addendum. We're looking at the addendum,
yes.
Right? Okay. Yes. I'm looking at the Arabic, and the right is written Shirkat Towns Square, and the left, Mr. Khaldoon Rashid Tabari, who signed.
And what's the writing underneath?
Under Khaldoon or Townhouse. Say that. Repeat that, please. Sorry.
Either. I want to know both, really. I want to know exactly what the writing says.
The writing said, I'm looking at the Arabic. Here it's in the right side, الطرف الأول, the first party, okay, and then a signature of Mr. Mahdi, and then Town Square Investment Company.
Right. Okay. That's what I thought.
And then underneath it there are a witness.
The witnesses, yes. And on the other side, the left-hand side,
Khaldoon Rashid Saeed al-Tabari. Second party, الطرف الثاني, second party, then a signature, then the name Khaldoon Rashid Saeed al-Tabari, and then the second witness, Ahmed Marwan Shaat, and his signature.
Understood. Yes. Is there anything else you want to say about the amending agreement, about the addendum? You were about to say something, and I think I stopped you.
Yeah, the addendum, I mean, it's a very another simple issue, which is they change the unit, that one of the unit that they are buying, and the second is amending the settlement amount.
Yes.
Amending the settlement. That's the only thing that addendum has covered.
Yes.
Good, and then listing, of course, of the checks and things like this, and that's it. But the main agreement is actually the loan settlement agreement. That's the main, where the obligation of Mr. Mahdi is drawn.
Yes. Now, just one more question, if I may.
Please.
In the documents that have been supplied, there's a list of payments that are said to have been made in relation to this loan, which suggests that out of the 30-odd million dirhams, some 27 million has been repaid. Is that agreed, or is that an issue between the parties?
It's not an issue between the parties because, Your Honor, you know this loan is actually from 2012. 2012, you know, and there was an agreed loan, principal amount and installments to cover the interest out of the use of this money to build the empire of Mr. Mahdi.
Yes. So what you're saying is that effectively it's the interest element that is largely missing.
Yes. No, it's been paid. So what's missing is the principal amount mostly.
Oh, right. Okay. Well, let me just be quite clear about what it is you say you're claiming then. What amount are you actually claiming?
Now, exactly 1 minute, please. 1 minute. To exactly give you the exact amount. Repayment of the outstanding loan amount minus interest will be 26,668,646. Repayment
26, 26,668,646.
Yes.
Right.
Repayment of interest rate of 10% on the loan amount, which is 11,274,911. Those are the amounts. Of course, there's legal fees and things, but this is what exactly the amount we're asking for.
I'm sorry, I haven't followed you there, Mr. Al-Suwaidi.
I said there's legal fees, of course, but I'm just
no, I understand legal
Oh.
fees are separate. We'll deal with that later. But the actual amount of the loan that you're claiming in terms of principal plus interest together, what's the total that you after?
Total, it would be 1 minute. 2, 6, 8. Four, 9, 1, 1. That 37,943,557.
$37943,557. Yes.
Yes. 43557.
And that represents the original loan
Plus interest.
Plus interest at the rate
Of 10%.
Where do I get the 10% from?
لحظة. I think it was the loan was 9%, 10%. 10% from the loan, the original loan agreement. I think. Because when they put the money to be paid, they put it on this after calculating all of that.
Yes. All right. Is there anything else you want to say at this stage, Mr. Al-Suwaidi?
No, I don't think. There's also this, this 55% of the value of unit handover, but that's record. It's okay, no problem. Okay.
Yeah.
I'm speaking with my colleagues here. I apologize. They're much better than me in the numbering, by the way.
That's all right. That's all right. Okay, well, now, Mr. Mithani, it's your opportunity. Let me tell you, I don't want to hear from you about the supposed shenanigans in which Mr. Tabari has been involved. That doesn't seem to me to assist at all. Whether or not there was some scheme whereby he could, Vision could get the money that he couldn't, is a different question that doesn't really arise here, as long as this is a legitimate transaction, which I can't question because there's no evidence of fraud or anything of that kind. So I'm not going to make any decision on the basis that Mr. Tabari is a crook, a criminal, a disreputable person or anything of that kind. The bottom line is very simple, and the points you need to deal with. relate to the nature of the obligation, which is an obligation to pay the amount of specific checks. That's the figure that's the only figure that can be the claim that's made against him on the basis of what is said to be a personal guarantee. Quite how that relates to any of the other figures that I've been given, I have no idea.
Thank you, Your Excellency. In terms of the figures, and also in terms of the claims that are made and what has been claimed, it's been a little bit of a moving target.
Yes.
It might be helpful if I just set out the parameters of what I understand remains on the table as at today. Because of course,
let me just tell you, because it may shorten things.
Yes.
On the face of it, there are 4 specific checks that are referred to, where there is an alleged personal undertaking to pay the amount if they bounce, and that amounts to dirhams 27,268,928. Now, that's the obligation on the face of it, which is sought to be enforced. Quite how what you've already paid relates to that figure, I have no idea at all. And that's where I might need some help, should at the end of the day I decide that this is an enforceable obligation. But you can come to that in due course. If you'd much rather deal with the main points first, that's fine.
Yes. So it is clear that the balance of the claim, which is being pursued as at today, relates to the checks. The claim in respect of the property, of course, has already been struck out, so that's no longer on the table.
Well, it's not a claim for the checks, Mr. Mathani, as put. It's a claim. And look very specifically at the words. It's a claim in contract as a guarantee if the checks bounce. So it's actually a claim for the amount of money that is in the checks, isn't it?
Well, if I may address that in due course,
yes. All right,
because I have a number of submissions and a number of grounds upon which I invite Your Excellency to dismiss the claim. It may be helpful if I start with a very simple point, which, if you like, is an overarching point, given the commentary that my friend made in relation to the 2008 crash and the background to what happened in Dubai. I actually arrived in Dubai in 2008 myself, about 6 months before the crash. Hopefully I didn't bring the crash with me from England when I came, but certainly although there was a crash and the background has been given, all of those matters are irrelevant, as is the suggestion by Mr. Suwaidi, which is a disputed suggestion, a new suggestion, in fact, that Mr. AMJAD somehow used this money to build his empire. That's something that's not accepted, because Mr. AMJAD was not a shareholder or beneficial owner of Town Square. Indeed, the shareholders of Town Square were 2 different individuals, and another, if you like, key defect in the overarching theme that's been put forward by Mr. Suwaidi is that his client has not brought a claim against the principal obligor. So there's been no claim brought by his client in these proceedings against Town Square, and there's never been a satisfactory explanation given as to
why does that matter? Why does that matter, Mr. Mathani, if at the end of the day there is a personal obligation here? There's no need for an application to have made to go to court to pay, get Town Square to pay, is there? If there's a guarantee, he's entitled to enforce the guarantee.
Well, I'm making the point at this stage simply by way of an overarching point, but in terms of the specific statutory provisions, I'll come to those in due course, if I may. So there are 5 grounds upon which I invite the court to dismiss the claim. Those have been summarised at paragraph 6 of my skeleton argument.
Yeah.
I propose dealing with each of them in turn, unless Your Excellency would find it helpful for me to take you through the factual background, which I've already summarised at paragraphs 8 to 13 of my skeleton argument.
No, just go straight to the grounds, please. Thank you.
I'm grateful. So, as to the first ground, the first ground is that VIH, the claimant, is not a party to the agreements, that's to say the LSA or the amendment, and that VIH was not the party that loaned the monies to Town Square. No reason has been given as to why Mr. Tubbery has failed to bring the claim in his own name, or indeed failed to bring the claim jointly. Now, VIH suggests that its claim falls within an exception to the privity of contract rule under UAE law. The defendant's position is that that exception doesn't apply, and also that even if the court accepts an argument by VIH that it had a joint right to bring the claim, because that was conferred upon it by the agreements, its claim would be bound to fail for non-compliance with RDC 20.10. I do also have the unlawful purpose argument, but you've given an indication in respect to that, and so I'll move on. In terms of the privity rule, there's no dispute between the parties that there is a rule of privity. But the question is, does it fall within the exception in Article 252? Now, Article 252 is set out at paragraph 21 of my skeleton. A contract may not impose an obligation upon a third party, but it may vest a right in him. Now, in my submission, that wording is quite specific. It doesn't say that it may provide him with a benefit, but it says that it may vest a right. So the right in my submission must be expressly vested, i.e. that a right which a third party can enforce. In my submission, the exception doesn't assist VIH in this case because neither the LSA nor the amendment vested any right in VIH. Mr. Tubbery in Town Square agreed in the LSA and the amendment that monies loaned by Mr. Tubbery be repaid to him by cheques drawn in the name of VIH. And it's been conceded by the claimant that this was no more than a payment mechanism. So this wasn't an enforceable right. It was a mere payment mechanism. And if one looks at paragraph 38 of the claimant's skeleton argument, that concession is set out in terms. It said the cheque served only as a payment mechanism. So at its most basic, the agreements did not state that they gave VIH the right to enforce any obligations under it. Any right of enforcement, therefore, remained with Mr. Tubbery, who was the counterparty. VIH didn't loan any monies to Town Square, and it would have been open to Mr. Tubbery as the counterparty at any time, and this is a key point, at any time to ask Town Square to pay the monies to his personal account or through some other payment mechanism. And in fact, if one looks at the LSA at page 898, I should say we've had some issues in relation to the page numbering in the bundle, because the page numbering seems to keep changing.
Doesn't matter, Mr. Thani. I've got a hard copy that I printed off, so just take me to the relevant bit.
I'm grateful. So page 898. There is the. Oh, I'm sorry. Page 898 is the amendment. I'll just take you to the settlement agreement, which is at 904. And it states that the second party shall also be entitled to deposit such checks. The second party is Mr. Tubbery. Deposit such checks to the bank, endorse the same to a third party, or deducted at bank. So what Mr. Tubbery has done is he's very cleverly retained the right for him to effectively move the debt to whomever he wills. So the right in my submission has always remained with Mr. Tubbery, and indeed there was a change in the amendment, as Mr. Tubbery asked for just over 4.4 million dirhams to be paid into the account of another company which was controlled by him, namely KRT4 Limited. And of course, VIH didn't sign off on that amendment because VIH wasn't a party to the amendment. And another way of looking at it is, if at some point Mr. Tubbery had said, well, I want the monies paid in a different way, VIH would have had no redress against Town Square or against Mr. Tubbery. So in my submission, it's clear that the right to enforce payment, both practically and legally on the agreement, always remained with Mr. Tubbery. And so if there's a claim to be brought, and we would say there isn't a claim to be brought, but if there is a claim to be brought, that's a claim that should be brought by Mr. Tubbery himself. We then move on to the point regarding locus standi. And here I would say that even if the court were to accept an argument by VIH that it has a right to bring the claim, that would be a joint right. They've never said that they have anything other than a joint right. And of course, the reason it would be a joint right is because of the way in which the LSA and the amendment have been drafted. And if that's right, it falls foul of RDC 20.10, which says that where a claimant claims a remedy to which some other person is jointly entitled with him, all persons jointly entitled must be parties, unless the court orders otherwise. Now, there hasn't been a request for the court to order otherwise, or any arguments given as to why the court should order otherwise. But in my submission, the court shouldn't order otherwise in any event, particularly given the issue in relation to creditors, which I appreciate that you don't want to hear me on that, and so I'm not going to go down that route. But there is a judgment of over 150 million dirhams which has been issued against Mr. Tubbery, and a copy of that judgment is in the hearing bundle. And so that he does have creditors in this jurisdiction who ought to be entitled to attach his assets if they want to. And so at the end of the day, if an order otherwise was made under 20.10, then that would potentially frustrate any such actions. The alternative submission that I've set out in relation to VIH not having the locus to bring a claim is that, and I set this out at paragraph 31 of my skeleton, that the ALSA doesn't even purport to confer a benefit, let alone a right, in respect of payment of sums other than the 5 checks. Now, I'll perhaps come on to numbers a bit later, but it's worth stating at this stage that those 5 checks include the interest element already, because the original, because the amount that's stated to be the principal is stated as being, I believe, if memory serves me correctly, 25 million in the LSA, and so anything above 25 million is an interest element, and there isn't in fact an additional interest clause within the LSA. So there's no independent clause in the LSA that says that anybody's entitled to 10% interest, as has been suggested by Mr. Suwaidi. It may be that Mr. Suwaidi was thinking about the original credit agreement that was entered into by Investbank, but of course that agreement is no longer in existence. That has been replaced. My second ground is that Mr. AMJAD is not a party to the agreements. It's not in dispute on the papers, at least, or at least on the pleaded case, that the parties to the agreements were Mr. Tubbery and Town Square. And in this respect, it's worth going back to the beginning, as it were, to the particulars of claim, which are at page 6 of the bundle. And if one looks at paragraph 8, it states very clearly, on the 12th of April, Mr. Tubbery and Town Square entered into a loan settlement contract with subsequent amendment to reschedule the remaining amount of the loan. Not Mr. Tubbery, Town Square, and Mr. AMJAD entered into an LSA, which provided for a guarantee obligation. So even on the claimant's own case, the claimant knows who was a party to this agreement and who wasn't. Later in the particulars of claim at paragraph 9, they talk about the defendant being a guarantor, but there's a gap, there's a jump between paragraph 8 and 9 as to, you know, where does this guarantee come from? How does that become a legally binding obligation? But it's worth looking at the agreements themselves, and I've set out at paragraph 32 of my skeleton the first paragraph of each of these agreements. This is from, in fact, the translation which appears at it's the translation which appears at page 604 of the bundle, and at page 898 of the bundle. But what is clear, whether one looks at this translation or one looks at the defendant's translation, is that the agreement itself very clearly states who it's between. It states that it's between Town Square LLC, a company incorporated under Dubai law, etc., and Mr. Khaldoon Al-Tabari. And it's worth remembering at this point that Mr. Tabary was and remains an extremely sophisticated businessman. He was heading up one of the largest contracting companies in the UAE at the time, Drake and Skull, which is the company that then brought proceedings and made a criminal complaint against him. So this is a very sophisticated businessman, and he's entered into an agreement which clearly provides for two parties to the agreement, Town Square and himself. Mr. AMJAD is not named as a party to the agreement. And likewise, if one goes to the signature strip at the end of the agreement, there are two parties, the first party and the second party. There's no the third party, MAHDI AMJAD guarantor, as would usually be the case in an agreement like this. And Mr. Tabary was being assisted by his team, including his lawyers, in the preparation of this agreement. So the only way in which, so if I can perhaps put the point in a slightly different way, neither the LSA nor the amendment was signed by Mr. AMJAD as a legal person. They were signed by Town Square, and they were signed by Town Square acting through Mr. AMJAD as an authorized signatory. And there's never been a suggestion by anybody in these proceedings that Mr. AMJAD was not an authorized signatory or somehow didn't have authority. And of course, it's understandable that that proposition has never been put forward, because if it had, then the primary liability would fall away and then there would be nothing left to guarantee. So in terms of, if one looks at the agreement objectively, who has the agreement been entered into by? It's been entered into by Mr. Tabary in Town Square. So given that Mr. AMJAD was not a party to the agreements, the only way in which liability could be imposed on him as guarantor would be if this was mandated by a specific provision of UAE law that imposed such liability. Now, no such provision has ever been cited by the claimant. And in fact, the provisions of UAE law which are in existence suggest exactly the opposite. So the starting point for the analysis would be Article 252 of the Civil Code. And Article 252 of the Civil Code is very clear. It says that a contract may not impose an obligation upon a third party, but it may vest a right in him. And it's worth, in this respect, looking at some of the case law, which perhaps I can take Your Excellency to. If I can ask Your Excellency to go to page 913 of the bundle. So this is a translation of an Abu Dhabi Court of Cassation case, which is persuasive authority. Your Excellency probably knows already that there's no doctrine of binding, generally, apart from one exception which isn't relevant here, there's no doctrine of binding precedent in the local UAE courts. So all of these authorities are persuasive. But if one looks at the Abu Dhabi Cassation case and goes to 913, specifically, the third paragraph, the Abu Dhabi Court of Cassation had found the second plea of the appellant to be also invalid. The court stated that Article 250 of Federal Law 5 of 1985, that contracts are not binding as to what they contain, except for those who were parties to them, and do not, according to Article 252, create any obligation in the charge of another. So there's Article 252, there's also Article 250, and it's worth just also having a look at, and I'll take you to Article 250 in a moment, although it's set out there. But I'll take you to Article 250 and also the Ministry of Justice commentary on Article 250, because that's quite helpful. But before I do that, I'd invite you to turn to page 919 of the bundle, which is the second case that I rely upon on this point. And that is a Dubai Court of Cassation case. So it's still persuasive, but it's highly persuasive. It's more persuasive than the Abu Dhabi Court of Cassation case. And the last paragraph on page 2, so this is a bit where it says decision. The court found this claim because according to the Article 250 and 252 of Federal Law Number 5 of 1985, subject to the rules relating to successions, the effects of a contract shall apply to the contracting parties and to their universal successors in title, unless it follows from the contract the nature of the transactions or a law provision that such effect shall not apply to the universal successors in title. And then it quotes effectively 252, the contract did not impose any obligation on third parties, but may establish a right in their favour. All companies except a joint venture company. This is not a joint venture company. Town Square was not a joint venture company. It was an LLC. Have a patrimony and a moral personality independent from any other one. And then if I can finally just take you to 923 of the bundle. That is Article 250 of the UAE Civil Code. It's the Whelan translation, which is probably the best translation in circulation, because it also contains the Ministry of Justice commentary on the Civil Code. So Article 250 that we rely upon says the effect of the contract shall extend to the contracting parties and to their general successors. General successors is a reference to inheritance. So if you die, then your trustee effectively stands in your shoes, without prejudice to the rules relating to inheritance, unless it appears from the contract or from the nature of the transaction or from the provisions of law that the effects do not extend to a general successor. So that second limb just relates to, does it extend to a general successor or not? But the commentary is instructive because the commentary says very clearly the effects of a contract are restricted to the contracting parties themselves. So they don't go anywhere else. To be bound, you have to be a party as a matter of UAE law. And then the final case I rely upon is at page 916 of the bundle. And again, this is another Dubai Court of Cassation case. And this relies upon Articles 151 and 153 of the Civil Code as well, which we also rely upon and are helpful. And again, I take you to the section just below decision. As Mr. Suwaidi alluded to earlier, the judgments of the local courts are often quite concise. The Court of Cassation held that the contract did not impose any obligation on third parties, but may establish a right in their favour. So that's clearly a reference to 252. Article 1449 of the Civil Code stated that unless the law otherwise provides, a contract may be made in person or through a representative. Article 151 of the same law stated whoever personally makes any contract for his own account, he alone shall be bound by its provisions. Well, 153 stated that should the representative within the powers of his representation conclude a contract in the principal's name, the provisions of this contract and all ensuing rights and obligations should accrue to the principal. And again, so far as obligations are concerned, it's saying pretty much the same thing as the other provisions I've relied upon. There's a reference to rights and authority of a representative, because of course a representative can't enter into something and thereby bind his principal to obligations if he doesn't have authority to do so. But this case effectively is also supportive of in my submission, of the proposition I'm putting forward. All of this then begs the question as to why proceedings have been brought against Mr. AMJAD, because he isn't the proper defendant to any proceedings. And you will have seen that previously, and I've set this out at paragraph 35 of my skeleton, there was a letter that was written to Mr. AMJAD by or on behalf of the claimant, saying that a judgment had been obtained against him in the local courts on the 8th of July for 32 million dirhams. But in fact, that was palpably false. It was blatantly untrue, because the Dubai Court of Appeal had on the 8th of July, in fact, dismissed the claim that had been made for want of jurisdiction, and in fact ordered Mr. Tabari to pay the costs of the proceedings, upholding a similar order by the Dubai Court of First Instance. So in my submission, the claim fails on that ground alone, and that's really the fundamental basis of the claimant's case. If the claimant fails on this point, they fail on everything. I then move on to ground 3, which relates to the extinguishment of the defendant's alleged obligations. So if you're not with me on my first 2 grounds, I rely on the third. Each of the grounds are in the alternative. So any obligation would have been cancelled or extinguished when Mr. Tabari and Town Square entered into the amendment for 3 reasons. Firstly, on the claimant's own case, the amount of the debt, the guaranteed debt, was modified by the amendment, as it required Town Square to pay an additional cheque of just over 435,000 dirhams, dated the 31st of March 2019. So there's actually an additional obligation there. And as a matter of UAE law, a guarantee cannot apply to a modified debt unless the guarantor has expressly agreed to a new guarantee. And I rely in that respect on Dubai Commercial Cassation Case 299 of 220, which the relevant extract of it I've set out in the skeleton argument, but the translation is in the bundle. In particular, I rely on the passage that says, if the underlying debts are settled or renewed, the guarantee must also be renewed accordingly. Otherwise, the guarantor shall not be liable for any renewed or modified debt or for any newly granted facilities. And then it goes on to say, a guarantee cannot be perpetual or indefinite, nor can it extend to a new, modified or renewed debt unless the guarantor expressly consents to a new guarantee or to the renewal of the previous one, treating it as a new guarantee for a new debt requiring fresh acceptance. And then going on, moreover, it has been established practice between the appellants and the first appellee bank, that was bank case, that a separate guarantee is issued for each new credit facility granted in accordance with customary practice. And as you probably, as Your Excellency probably knows, customary practice is a source of law in the UAE. So on no view did Mr. Amjad expressly, it's a high bar that has to be met in relation to a modification of a debt. And on no view did Mr. Amjad expressly consent in his personal capacity to a new guarantee. In fact, not only was there no signature of a separate guarantee or a new guarantee, but that was, you will have read Mr. Fatty's witness statement, and you will have seen the track change document. There's no reference to a guarantee in the amendment, which conveniently brings me on to the second point under this heading, which is that the amendment operated as a replacement of the obligations under the LSA because it set out the obligations of the parties going forward exhaustively, including the obligations which had previously been contained in the LSA, such as in relation to the payment of the checks. And so because that guarantee provision had been effectively, or alleged guarantee provision had effectively been removed, it could no longer be regarded as being operative if it ever was operative, and I would say it never was. And then the third ground here is in relation to the operation of Articles 1088 and 1099 of the Civil Code. I don't propose taking Your Excellency through those unless you would find it helpful. I've set them out at paragraph 41 of my skeleton argument.
1088 doesn't help you, does it? Because that talks about satisfaction of the debt. And it's hard to say a debt is satisfied by further promise to pay. Article 1099, I understand.
Yes. So the argument under it's a question of how one interprets Article 1088. But the submission I would make is that there is a satisfaction, because what has happened is that one thing has been replaced by another. So one set of obligations under the LSA has been replaced by a new set of obligations. And the new set of obligations includes an additional check. It includes a different property. It includes payment to a different third party. So you have a different package of obligations, and the second package of obligations replaces the first. In a sense, it doesn't, I've set out 1088, but in a sense, it doesn't really add much more to the modification argument. It's perhaps it perhaps gives a statutory basis for it, but the basis for it, the modification argument, is well settled as a matter of UAE law on the basis of Court of Cassation precedent anyway. So I don't have to rely on 1088, but it's there if Your Excellency finds it helpful. The fourth ground I rely upon is that the underlying loan was unlawful. Now, the agreements provided for Mr. Tabari, who is not a licensed individual, to loan monies to Town Square on interest. For this purpose, it's worth going back to the beginning of the story, as Mr. Suwaidi took us at the beginning of his submissions. And what happened at the beginning of this story was that Town Square borrowed monies from Mr. Tabari. It wasn't Mr. Amjad who borrowed monies from Mr. Tabari. It was Town Square. Mr. Amjad merely made the introduction to Town Square. But the monies were borrowed through a credit agreement the credit agreement, it's a long agreement, but when one looks at it, the essence of it is there. The essence of it is, although it's been put together using a slightly different mechanism, but the essence of it is that money is being lent effectively by Mr. Tubbery through Investbank acting as an intermediary to Town Square. Now, why would anybody enter into an agreement like this? Why would anybody use a bank? Because the bank takes its cut. The bank takes its percent, and Investbank did take its cut. But the reason Mr. Tubbery used this mechanism was because that was the only legal way of doing it as a matter of UAE law. Otherwise, why are you giving up your however many basis points? So he entered into the agreement using this mechanism, and there may be arguments as to whether an arrangement such as this is a sham or isn't a sham, but that's not something that's before this court. The fact is that the credit agreement was a mechanism that was used to avoid the prohibition. So when Mr. Tubbery then entered into the LSA at a later stage, directly with Town Square, directly loaning the monies to Town Square, well, he no longer got around the prohibition because he'd taken Investbank out of the picture. It would have been just as easy to enter into a tripartite LSA or amendment or ALSA, including Investbank, but he didn't do that. And in the UAE, the only persons who are licensed by the central bank may lend money on interest under Article 65 of the Federal Decree Law 2018 regarding the central bank, the organisation of financial institutions and activities. And I can take you to that at page 426.
I don't understand this point really, Mr. Mithani. This is a loan settlement agreement in which they make provision for payment of cheques. The whole point of that being to avoid the whole question of interest. It's cleverly done in order not to amount to a breach. You've got a loan settlement agreement in relation to a loan that's originally been made, and it's all done with cheques which have the inbuilt element of interest in it in such a way as to make it legal, isn't it?
Well, it unfortunately it doesn't work in that way in my submission, because as a matter of UAE law and also as a matter of Sharia law, on which which if you like is an underlying theme that runs through the UAE legal system, one looks at the substance of something like this, and not only as a matter of substance is there interest, because what is being charged is more than what is owed. So there is an interest element, but the agreement itself, I think it's perhaps helpful if we go to the agreement itself.
Do you say the cheques couldn't have been enforced?
Well, as to sorry, is your
my question is,
yes.
Could there have been a legitimate suit on the cheques? And the answer must be yes. Unless you say the whole arrangement is completely unlawful, void for illegality, and the cheques therefore couldn't be enforced either. I mean, I think that's what you have to say if your argument is to hold good.
Well, that's what I do say. I then say something else later, which is that the cheques are limitation barred anyway. But so far as the interest is concerned, the cheques. Let me just go to the agreement, the LSA.
Well, the only money that is actually being paid. First part shall pay 32 odd million dirhams as follows, and then you've got the bit relating to what's paid to luxury developments, and then you've got a series of 4 checks, and the special provision that is
Yes,
relied on.
but
And exactly the same thing happens when you come to the amended loan agreement. There's no provision for interest in it because, as you rightly say, the interest element has already been built into post-dated checks.
the interest element has been built into post-dated checks, but it's still an interest element. Just because it's been built into post-dated checks doesn't mean that it's no longer interest. It remains interest.
Right. So you do say the checks are unenforceable.
The checks are not enforceable. Yes, I do say that.
Right.
And
where's the provision upon which you rely for this?
well, the provisions that I rely upon are the general provisions that are set out in my skeleton at 43 and paragraphs 43 and 44, which provide as a matter of regulation.
44 may impose a criminal penalty, but that doesn't make the transaction necessarily unenforceable, does it? Does Article 65 specifically say it's unenforceable? I'm not sure. I haven't seen Article 65 yet.
Yes, so Article 65 is the regulatory provision,
Right.
which has in fact been interpreted by the DIFC courts previously in NS Investment against SETI, and if it falls foul of if a loan agreement falls foul of Article 65, it isn't enforceable, and the reason it's not enforceable. It's an argument that is in 2 stages. The first stage of the argument is to ask the question: does it fall foul of Article 65 or Article 409 of the Penal Code? If the answer to that is yes, then it is unenforceable as a result of a different provision of the Civil Code, which is, give me a moment.
Article 129, is it?
Which is Article 129. The essentials for the making of a contract are there must be a lawful cause for the obligations arising out of the contract. And so if it falls foul of the regulatory obligation, there is no longer a lawful cause. And it's worth having a look also at the NS investment case at page 570. In particular, paragraphs 40 and 41. Well, paragraphs 34 and 35.
Sorry, where am I looking for this?
So this is page 570 of the bundle. Which is the NS investment case.
Right. Give me the paragraph number, because the
Yes.
the download that I've got is on slightly different pages.
So it's paragraph 34 and 35.
Thank you.
So 34 and 35 deal with the first stage of the test, i.e. the illegality.
Sorry, paragraph or page?
Paragraph.
Paragraph. Yeah, the skeleton argument I'll be talking about.
No, he's talking about the case, the NS investment case that's referred to at paragraph 43 of the skeleton argument.
Okay.
And it's at in my copy of the bundle that I downloaded, it's page 562, but I think Mr. Mithani says it's 570 in the current bundle.
Okay.
Yes, unfortunately, there's an oddity in the bundling system where the pages on the downloaded PDF don't correspond with the online bundle.
Yeah. But where does it specifically say it's unlawful? That's what I'm looking for.
So that's 34 and 35, and then if one goes further into the judgment,
yeah,
in this case there was a suggestion that, well, this was a one-off transaction. It wasn't somebody acting as a bank, and the court rejected that at 40 and 41. And then if one goes to the conclusion of the judgment, the judge says there was no competent legal capacity to enter into this loan agreement. That was a different argument that was being run in the case. And then a court will not enforce an illegal contract or provide remedies that may arise out of it. A contract will be considered illegal at its formation when it's incapable of being performed without an illegal act. And so this was a conclusion that was reached in this case, that it was an unlawful contract. It couldn't be enforced, and the court relied upon the same provisions that I'm relying upon in this case. And just
so it wasn't just the interest that was unenforceable. The whole loan was unenforceable.
Well, in that case, it may have been. In that case, it may have been the. It may have. In that case, it may have just been the interest element. But in my submission, but this wasn't a guarantee case.
No.
But my submission is, in this case, the entire, if there was a guarantee obligation, the entirety of it would be, the entirety of the guarantee obligation would be unenforceable, because there's a clear distinction between a personal guarantee and a principal obligor who takes a loan. If there's a principal obligor who takes a loan and the interest that's being charged is illegal, then it would be understandable if the court said, well, the interest is illegal, you don't have to pay the interest. But so far as the original monies are concerned, you have to give them back, because otherwise it would be unjust enrichment. But so far as a guarantor is concerned, that's simply not an argument that's there, because there is no unjust enrichment.
Yes.
Just going back to the point about interest, but both the amendment and the perhaps unhelpfully for Mr. Tabery, both the amendment and the LSA specifically refer to interest. So, for example, the amendment in the paragraph just above, secondly, the obligations of the second party, says that thus the total amount of payment indicated above is 32.1 million as remaining balance of loan amount and its interest.
Yeah, well, if you go back to the order at the beginning of it says very specifically the loan agreement is null and void in the actual order. Back at page 562 in the PDF.
Yes, yes.
Yeah.
Yes, so even in this case, so far as the agreement was concerned, the loan agreement, the whole of the loan agreement was null and void. So,
yeah. All right, I've got the point.
There's a second case which I've cited, which is Reuter. I won't take you to that unless you want me to, but it doesn't really take the argument much further, because in particular it didn't consider Article 65, and that was a case in which the defendant didn't appear at trial, and so these arguments were not put properly. And the additional point here, in this case on the guarantee, is the point that I set out at paragraph 44 of my skeleton, namely that the wording of 409 of the Penal Code imposes a penalty upon any natural person who deals with another natural person by usury interest in any kind of civil or commercial transaction. And so if the claimant's case were to be accepted and Mr. Amjad was a guarantor, there would have been a dealing, in inverted commas, between two natural persons on interest. The word usury doesn't add any additional gloss. That's just the way in which it's translated. So it's not about the percent of the interest, for example. And if you go through Reuter, it's clear that interest is interest. It's not about the amount.
Yeah.
And so the conclusion is that it is void. The guarantee is void as a whole under Article 129 of the Civil Code. And if you're not with me on that primary argument that the whole of the agreement is rendered, the whole of any alleged guarantee obligation would be rendered void, at least any interest element would be rendered void under Articles 204 and 714. That brings me to my final argument, which is in relation to the claim being limitation barred. This argument has got two limbs. The first limb relates to Article 1092, and the second limb relates to Article 671. The Article 1092 argument I've set out in some detail at paragraphs 50 to 55 of my skeleton argument. I don't propose taking you through those unless it would be helpful, but I would like to take you through the Article 671 point.
Fine.
So on the Article 671 point, we only get to that if you find that this is a commercial transaction. We say it's not a commercial transaction. We say it's governed by the Civil Code, and so Article 1092 applies. But if you were to find that it was a commercial transaction, it's limitation barred under Article 670 subsection 1, That provision provides that a claim for recourse by the holder of a cheque against the drawer, endorsers, or any other parties liable for payment, it's drafted in wide terms, shall not be heard if 2 years have passed from the expiration of the period for its presentation. Now, on the claimant's case, the defendant guaranteed the payment of the cheques referred to in the LSA, and thereafter the amendment. There's been a slightly different suggestion now made by Mr. Suwaidi in submissions. What he suggested is that what was being guaranteed was the underlying contractual obligation, but that is not what the agreement says. The agreement is, in fact, very clear as to what it is that is allegedly being guaranteed. And if we just go to the LSA, and of course, I'm not inviting Your Excellency to go to the amendment, because the amendment didn't even contain an alleged guarantee clause. But the LSA at page, it's 906 of the bundle, but it's the section that's just above the word, just above the subheading that says, secondly, the obligations of the second party. The clause says, in the event of any of the indicated cheque is returned unpaid, then Mr. MAHDI AMJAD shall be the guarantor and be personally responsible for the payment of returned cheques amount if the first party failed to pay the same within 90 days after the due date. So the obligation, even on their case, that's being guaranteed is the cheques. It doesn't talk about the underlying contractual obligation. It talks about the cheques. And as one would expect, as a matter of UAE law, guarantees are to be construed strictly. And particularly, Cassation Case 299 says, in cases of doubt, the interpretation of the guarantee shall be in favour of the guarantor, which is at paragraph 60 of my skeleton argument. So from that provision, it's the cheques, it's not any underlying contractual liability. So in my submission, there are then two reasons as to why the defendant cannot have any liability in the capacity of guarantor as a matter of limitation. Firstly, there's no liability under the cheques, since the cheques themselves are limitation barred, as no claims were brought on the cheques before the DIFC court or judgment obtained in any other court on the cheques before expiry of the limitation period. And secondly, it's well settled that a guarantor is entitled to avail himself of any defence that would be available to the principal obliger. So if a claim was brought on the cheques against whoever signed the cheques, or from whoever the cheques were made out, then they would have a limitation defence. So Mr. AMJAD effectively has the same limitation defence. So that's the first argument. The second argument is that even if you are not with me on that, one goes back to the section itself, Article 670, and that relates not only to a claim for recourse by the holder against the drawer or endorsers of the cheque, but also any other parties liable for payment. Well, the whole basis of the claimant's case is that Mr. AMJAD is liable for payment of the cheques, and that has a 2-year limitation period. And just to square the circle, in terms of dates, the claim in these proceedings was issued on the 15th of August, which was more than 2 years after the expiration of the last check, which was the 31st of March 2019. There are a number of arguments which have been put forward by the claimant on this limitation point. Not all of them seem to be pursued in the skeleton argument, but it may be helpful if I address you on them. The first was that the obligation was tied to the underlying debt, not to the check. As I've set out, that is incorrect, because the obligation is tied to the checks, not the underlying contractual obligation. And in fact, on this point, the claimant itself makes the concession in its skeleton argument. So if you look at page 2 of the claimant's skeleton argument, at paragraph 15, they say, this is exactly what's pleaded in paragraph 10 of the particulars of claim, and the convenient interpretation advanced by the defendant cannot prevent the claimant's claim based on the bounced checks. So the claimants themselves accept that the foundation of their claim rests upon the bounced checks and not upon any underlying contractual obligation. That's in their own skeleton argument. The second argument that the claimants run on this point is that guarantees in commercial transactions imply joint liability unless expressly excluded, and that the defendant remains jointly liable. And they rely on Article 72, which deals with joint liability as between guarantors, but Article 72 actually deals with joint liability as between guarantors, not as between a guarantor and a principal obligor. There is another provision that, just for the sake of transparency, that does relate to joint liability between a principal obligor and a guarantor. But the key point here is that even if one considers there to be a joint liability with the debtor, one still has to go, the point doesn't go anywhere, because one still has to go back to what it is that the guarantor has guaranteed. And in this case, the guarantor has guaranteed, allegedly, the checks, not any underlying contractual obligation. And the difficulty that causes the claimant is that the claim would then also be defective, because Town Square, if it's a joint liability, Town Square has not been joined as a party. So that goes back to Your Excellency's question at the start of the proceedings, as to why should a claim have been brought against Town Square as well? Well, according to the claimant, there's a joint liability. And so how can a claim be brought where there's joint liability if both of the parties are not joined? The claim is defective, it's not properly constituted. The third argument that the claimants rely on, I've dealt with at paragraph 63 of my skeleton. I can address you on that if you want me to, but it seems that it's no longer pursued by the claimant in their skeleton argument. And in any event, it relies on Article 104 of the DIFC contract law. The DIFC contract law isn't applicable in these proceedings because the proceedings are governed by UAE law. I should address finally, just for the sake of completeness, the unjust enrichment argument, which the claimants have put forward under Article 318. that argument in my submission doesn't go anywhere, because first of all, one has to look at what 318 actually says. And 318 says no person may take the property of another without lawful cause. And if he takes it, he must return it, which is quite it's quite an obvious proposition in a sense. But it doesn't operate to defeat a limitation argument. And there's been no authority cited to suggest that it does. That's the first point. The second point is that Mr. AMJAD hasn't taken any property belonging to the claimant, or indeed Mr. Tubbery, let alone taken it unlawfully. And thirdly, even if one were to accept that 318 gave rise to a broader unjust enrichment principle, the claimant has failed to prove that Mr. AMJAD has been enriched, given that he was not even a shareholder in Town Square. And then the final flaw in the claimant's argument is that, and this again goes back to Your Excellency's question at the start of the proceedings, that it would be open to the claimant to bring a claim against Town Square for payment of monies it claims it's owed by Town Square, but hasn't done so. So they can't say that they've somehow lost out, there's been unjust enrichment, if they just haven't brought a claim against the right party. They had suggested earlier in these proceedings that they were going to join Town Square as a party, but they never did. And then the Article 246 good faith point, the answer to that is really similar. And good faith, as Your Excellency may know, it's sort of the last resort, where if one doesn't have any other arguments, one relies on good faith. But again, it doesn't go anywhere, because the answers to the good faith argument are the same as the answers to the 318 point. Would it be helpful if I address Your Excellency on numbers as well?
Very briefly, I just want to know how they fit into either side's case.
Yes.
I mean, I understand your primary case, of course, but
yes.
But if we were looking at specifically what is quote unquote undertaken in the LSA, on the face of it, we're looking at 4 particular checks with a total of some 27 odd million dirhams. And the question that I have in my head is, well, how does that relate in the overall context? Self-evidently, if the whole loan had been fully paid, then it wouldn't matter if the checks had bounced. So the question then is, you wouldn't be entitled to anything, would you? I'm sorry, the claimant wouldn't be entitled to anything. Yeah. So the question is, how do these 4 checks relate to the overall position, and in particular the payments that you say that you've made, as outlined in the material exhibited?
Yes, so of the 27.7 million mentioned in the agreements, there were 2 payments which have been made subsequent to those agreements being entered into. One is a payment of 4 million, and that was a check. And then the second payment was a payment of 150,000. So that would bring the number to 23,554,657.
Ah, right. Okay.
But part of that number, within that number, is inbuilt an interest element, which, if you were with me on my secondary interest argument, that interest element would come out. If you were with me on my primary interest argument, that would defeat the entirety of the amount.
Look at your paragraph 68.
Yes. Yes. So the total that was paid was just over 27.206.
Yeah.
And that's on the original loan. That's on the original loan amount. So the 27 includes payments that were made under the credit agreement.
I understand. I'm with you now. Yeah, I see. Yes, I've got you. All right.
And then, as a final point on interest, I should say that there is no, and I think I did mention this earlier. There's no separate freestanding contractual interest provision under which the claimant would be entitled to continuing interest. And so far as statutory interest is concerned, none has been pleaded.
Well, it'd be a matter for the court's discretion, though, wouldn't it?
It would. I would make the submission that if they haven't pleaded it, they're not entitled to it.
Right.
But you have my primary argument. My primary
I
argument
do.
is we don't get
Yes. All right. Anything else you want to say?
not unless there's something else I can assist with. If I can just have one moment to take instructions.
Yes, of course.
I'm grateful. No, nothing else. Right.
Right, Mr. Al-Suwaidi, you have a right of reply.
Yes. Haven't been a UAE lawyer, I would have been very much convinced of what Mr. Mithani has said. But I am a UAE lawyer. I'm sorry, Mr. Mithani, I don't agree with you and the way you have interpreted the UAE law. And I mean, just going into this last point that you just said about your client has paid 27 million, and you admitted in the same time it is a 30 million loan. 12 years, 12, yeah, 2015, yeah, we're 12, almost 13 years now. Okay, if your client would have really shown a good intention, she should have paid the remaining. You said 3 million. There's remaining. Why they have not paid? Why? Because your client is just don't want to pay anything. He just want to go away from his responsibility. If you this is just for the, talking about the last issue that you just raised. So that just to show, Your Honor, the bad intention of the defendant. This is number one. Number two, if we want to talk about Article 409 of the Penal Code, if it is illegal, the action that was taken by my client, why your client has not really filed a criminal action against my client in this regard? You could have brought a legal action, and then it will incriminate my client, and then you take this award in your favor to stop this judgment from going forward, or the case from going forward. And you rightly said it's between two natural persons. This was not done by two natural persons. It was done by banks, and then it went to a natural person with a company. Okay? And the other natural person with Mahdi is the guarantor. If you look at the original agreement, when you talk about this is Mahdi is not involved, it was sent to a company. So look at the original agreement. Mahdi was a signature. And then when later on they defaulted in payment, they went and made this arrangement, and they made the arrangement, and Mahdi signed again, both capacity in my view, and he signed under that piece of paper that shows that Mahdi will be the guarantor. He signed, he agreed to it, he knew what he's signing for. Whether that agreement is really prepared by lawyers or not lawyers, I really don't know. I was not there, and I was not representing him. Why it was not signed, written the name of the lawyers who prepared it, I don't know. But the previous one, you see how many pages they were written. Here, maybe 4 pages, just to show how we are usually deal with each other with trust and reliance on what promises is made. So it was only 4 pages that I think the loan agreement, loan settlement agreement. Going to Article 72 of when you talk about the joint liability. And in Arabic, the word is tadamun. Tadamun mean joint liability mean the law give you the right, okay, to have the full claim against any of them individually. Even if a judgment comes to them against them, you can go against one and enforce that judgment against that one. He said, if say like 2 individuals that you already sued and they are mutadaminin, joint liability, as per the UAE law, that means I could take this judgment. It's a judgment for $100. Okay, no, $100 will not go to court for that, but $100 million. I could take it and enforce it against one of them for the whole amount. And he cannot argue, well, enforce 50%, 50 million on me and another 50 million on the other side. No, I could enforce it against any of them, even if the judgment came against both of them. This is what means tadamun mean. So I'm sorry, Mr. Mithani, you're taking it out of context. And this is a right, not an obligation. It's a right. I could go against them, 2, or against 1. Okay? With regard to this interpretation of Article 250 and 251, Your Honor, it's really worth going to that law, and you see how it really specify those 2 articles. There is no contradiction between Article 252, which we rely on, or Article 251 or 250. They are not contradicting each other. It just it sets different scenarios. In the very beginning, 250, it talks about if someone passed away, and then his heirs will take over. Now the heirs are third party. So usually they will take this right, unless specifically those are not, and it could not be inherited, or this is really something very specific for that person. And if you go to Article 252, it talks about, 251, it talks about maybe you are renting a place, something like this, and then when you rent that place and you talk that out to some third party, subleasing or something, and or you not subleasing, maybe you're going out of that rent and then you give that rent to someone else, third party, and the landlord accepted, and that it goes with that kind of what I'd say, that rights with that goes with this. So as it talks about in the first 250, it talks about I'm sorry, I'm not, I mean, I'm thinking in Arabic, I'm trying to translate it in English, so I apologize for. It says al-khalaf al-am. Khalaf al-am is mean the heirs. And the khalaf al-khas in 251 means anyone you have assigned your rights to. 252 talks about different, scenario. It talks about the rights two party can give right to a third party, but they cannot oppose obligations. Now, when we talked, if you look at the law, when you look at the agreement about the checks, is it a checks or the payment, the word, the amount of those checks? Because those amounts are what is the loan is all about. It's not the checks, we're talking about the amount. If you look at the translation of his obligation, Mr. Mahdi, is to pay the amount of that. So it's not the check, it's the amount of those checks. I mean, I would like to draw the attention of Your Honor also, please. In the order given by the judge on 19th June 2024, the court order, I would read that in paragraph 21. It says, as the guarantor clause was written clearly and unambiguously, and the guarantor themselves signed the agreement. By admission, there is no need for the claimant to find certain statute or precedent to assert that the applicant assumed a personal obligation by signing on behalf of the Town Express. So this issue is already been decided. They said, I'm sorry for that. My Italian is my Latin is not really that great. Res judicata. I'm sorry, I have to apologize. You understand what I'm saying?
I do understand what you're saying.
It's already been set, and it is really interesting for this. Why this is so important? Because this order is actually, written by His Excellency Judge MAHDI, and he is actually used to be a civil lawyer. He used to be a civil lawyer, a judge in Dubai court. Then he shifted the IFC. So he is actually qualified in both jurisdictions. So he knows very well the UAE law, and he is the best to interpret it, and he interpreted it in our favor. What else? I think for the time being, this is all. Anything I think I did not think I missed anything. Thank you very much for your time, Your Honor. I'm done.
All right. Thank you very much. Mr. Mathani, you look like you want to say something.
Yeah, sorry, just one very short point, Your Excellency, because it was a new point that was made by Mr. Suwaidi in reply in relation to the order of the judge who dealt with the strikeout, Judge Ali. He suggested that this point was res judicata. The point isn't res judicata. That was an order that was made on the defendant's strikeout application, and it was a judgment that was given on the defendant's strikeout application. And so obviously the judge didn't have the benefit of the same evidence that and the same arguments that were put forward before the court today. So it's not res judicata. He effectively found that we didn't meet the threshold for a strikeout or an immediate judgment application.
Yeah, no, I understand. All right. Well, that's all then. I shall reserve judgment and put it in writing, and you'll get something in the course of the next few days.
Thank you.
All right.
Thank you very much. Thank you.
Thank you very much.
We're looking forward for your favorable judgment, by the way.
If you'd like to sign out, I'll have a quick word with the associate, if I may. Thank you very much.
Thank you. Pleasure seeing you. Thank you very much.